Hi, my name is Eric Willison. I'm an attorney certified to practice in Ohio since 1996. If you're thinking about representing yourself, I'm going to want to tell you a little bit about what a court case is going to look like from the macro point of view, from the very broadest outlines, so you can kind of know what you're getting into. So basically, with any self-representation. Now, there's going to be exceptions to this. You could have very small cases, very sort of procedural things, small claims court, not going to be like this. But if you're going to get into any court where the rules of evidence are going to apply and the rules of civil procedure are going to apply, then you're looking at basically what I would say is a four-stage proceeding. The first stage you're going to enter into is what's called the pleadings stage. That's where someone files a complaint against somebody, and then that somebody files an answer back. Maybe they also file their own complaints, they're called counterclaims, and then the original person would then file a reply to those counterclaims. Or maybe they bring in third parties because there's some relationship there, and then those parties would come in. But this initial stage, it's called the pleading stage. One of the key things that has to happen in the pleading stage is you have to get service of process upon the defendant. The court has to have jurisdiction over all the parties. Now, when the plaintiff comes walking into the court and pays the filing fee and files his complaint or her complaint, that's easy. The court's got jurisdiction over that person, okay? But now he or she has sued somebody or some company, and you can't sue somebody in secret. You have to put them on notice that they're being sued. And the way you put them on fair notice is through what's called service of process. Now, here in Ohio, it's Civil Rule 4. Federal rules, it's Civil Rule 4. Most places, it's going to be Civil Rule 4 of whatever state you're in. But what it basically says is that you have to go out there and let this person know they're being sued and give them a copy of the lawsuit or get a copy of the lawsuit to them so that they can file an answer, okay? Now, the way it works in Ohio, almost always, is that you file the complaint and several copies of it, and then you request what's called certified mail service. And then the clerk of courts will send the pleading, the complaint out to the defendant at whatever address you have for the defendant, and that will be, the mailman comes and tries to get them to sign for it. Now, some defendants are real sneaky and they try to, certified mail, I'm not signing for that. And so they won't sign for it, or they'll refuse it, or so it'll come back as unclaimed, or it'll come back as refused, okay, even after 2 or 3 attempts. At that point, what the court will do is then they will send it out ordinary mail. And if the ordinary mail doesn't bounce back as, gee, that's a bad address, or, we tried to deliver this and they wrote down there's no such person here, and now you still don't have service of process yet. So then you may have to hire a process server, somebody who's maybe a private investigator, who can tail people. You give them a picture of what, this happens in divorce cases a lot, where one spouse tries to play it clever and I'm just not going to be around to get her emotion or whatever. No. So, but that first thing, it's got to be served on them, and then the process server will walk up to them. They can be kind of sneaky. You get some really good-looking girl comes on to you at the bar. She's talking you up. You're talking her up, and then all of a sudden she says, "Oh, could you hold this for me for a second?" And then you hold it, and it's a piece of paper, and it's the complaint, it's the summons, and she says, you've been served in a case, and that's going to be in front of the, whatever, and then you may throw it on the floor. You may say, F you. You may say, what? You've been served, okay? You've been put on notice. That's that. If you want a chance to leave it on the floor, at this point, it's fair for the court to exercise jurisdiction over you. Sometimes there was a case we read about in law school in New York City where some person was living in, I believe it was the Waldorf Astoria Hotel, and they had some really burly security doormen there that wouldn't just let any old riffraff in like process servers, and so they couldn't get to this person that they were trying to serve. So, but they didn't know what room the person was in. They looked at an architectural plan of the building, and lo and behold, they could figure out what window was this person's window. And it was only like the second or third floor, so they wrapped the complaint up around a rock and some rubber bands or some twine or whatever, and they threw it through the window, smash. Then, of course, they went right over to the doorman and, said, hey, we're the people that smashed the window. We'll pay for it. That's fine. Here's the number. But that was considered good service because it got in, and here's the person looking out the window saying, what the heck is going on? You've been served. There it is. It's good service. Okay, so you put the person on notice during that pleading stage. Once they've been served, then at that point they have a choice to make. They can either file an answer or they can file a motion to dismiss. Now, a motion to dismiss it's going to sound a little bit like the third stage, dispositive motions, and we'll get to that, but it's not quite the same. On a motion to dismiss, it's really hard to win these, because what you have to do, what the court's going to do is, the court's going to say, okay, for the purposes of this motion to dismiss, I'm going to assume that every single thing that the plaintiff said in here that's a factual assertion, I'm going to assume that's true. Now, if all that's true, do they have a case? If they do, then the case goes on, and you've got, a week or so or 2 weeks to file an answer and keep on moving with the case. But what happens if it's some really bizarre case, like somebody sues you for wearing a green shirt on Wednesday? The court looks at that and says, green shirt on Wednesday, no law against that. No common law actions for wearing green shirts on Wednesdays. So even if I assume that it's true that the defendant wore a green shirt on a Wednesday, it's not against the law. This is ripe for a motion to dismiss, so therefore I'm going to dismiss it. Now that's a ridiculous example, but when you get into pleadings on certain things, there are elements that you're going to have to prove. And therefore, they're usually elements you're going to have to allege. And so if you don't allege the proper elements, then you might be ripe for a motion to dismiss. Now, one response to a motion to dismiss, of course, is, can I amend my complaint? I forgot a few facts or whatever. Yeah, you can do that. Okay. But anyway, eventually you're going to get around to the point where you're going to have to file an answer or not. And then you file your answer, maybe you file a counterclaim, and then the plaintiff would reply to that counterclaim. Now we're done with the pleading stage. That's usually going to take maybe a month and a half or 2 months, maybe if there's some complications, especially with service of process. Oh, and if the process server can't get you, and nobody knows where you are, you've left town, you've disappeared, you're on the run or whatever, last resort is you could do what's called notice by publication, where if you run an advertisement in a paper of legal circulation in the area for a certain number of weeks, saying there, so-and-so, there's a lawsuit, you should come by and answer, then that's disfavored, but if it's the only thing you have left, then you can do that, okay? So the next stage we get into is what's called the discovery stage. Now, everybody in here or watching this video, if you're older, you've probably watched the old Perry Mason. He was this Hollywood attorney from the 50s. He played an attorney. During the 80s, there was Ben Matlock. In the 90s or 80s, late 80s, and there's LA Law and things like that. And these law shows, basically Boston Legal, and basically all of these TV lawyers, they get on there, and all of the cases are always solved in the last 5 minutes of the show, usually by somebody pulling a rabbit out of a hat, some trap that somebody set for somebody, something they didn't know was there, or some piece of evidence that just now surfaced, or that they had held in reserve or whatever to really get them. The exception to that would be the Law and Order series. Those were generally pretty good. But this used to actually happen a little bit in courts before what was called the discovery rules. And courts didn't like it when cases were decided by ambush. They didn't like it when cases were decided by surprise. They didn't like that. And there's some really solid reasons for that. Number one, if you pull a rabbit out of the hat at the last second and show it and say, aha, I got you with this rabbit, how do we know that's a rabbit? What if it's the wrong kind of rabbit? What if it's not really a rabbit? What if it's a stuffed animal? But we really didn't get a chance to see it all that much, but the defendant broke down and admits it or whatever. That not being able to really assess the evidence and the strength of the case against you is sort of not what the court wants. The court wants people to know what the other side has so that each side can make a rational decision about proceeding forward with the case. The court's dockets are clogged, and the more each side knows about what's going on in the other side's case, the more likely it is that there's going to be either a settlement, or if we do get to a trial, we're going to have a trial that proceeds rationally and predictably with everybody knowing everything, and we're going to see a good solid presentation of the facts and the law, and have a good show for the jury so that the jury can be put in the best possible position to do justice, okay? It's not going to happen if you do it like they did it in the TV shows. So towards that end, we're doing an analogy here. Let's say that a lawsuit's like a poker game. Discovery is the mirror that you put behind your opponent, and he puts a mirror behind you, and your opponent can now see the cards in your hand just as you can see the cards in your opponent's hand. That way everybody knows she's got a full house, I've got 2 pair, I'm out of here, I gotta fold, I gotta settle this case, okay? Much better than a surprise ending, okay? So towards that end, you've got some discovery tools in almost all courts. You've got Rule 34, request for production of documents. You can ask the other side to produce any evidence they have that they think supports their claim, produce any evidence that they're intending to use at trial. If they've got records that could help your case, you can say, I want these records, I want those records, and so on and so forth. And they have to turn them over so long as those records aren't privileged. We can get into that in later videos. But they've got to turn the evidence that you're looking for over to you if they have it. A second discovery tool is what's called the interrogatory. The interrogatory is where you can send up to 40 questions to the other side, and they've got to answer those questions under oath. They've got to sign in front of a notary saying that the answers that I provided to these 40 questions are true. They may be something like, why did you do this? When did you do that? Who were you with when you did this? What were you doing on this occasion? You've got to answer these things to the best of your ability. If you don't know, you don't know, okay? But you've got to answer the questions. So that's the interrogatories. And whenever you get a request for production or interrogatories, you generally have about 30 days to answer. If you need more time, you can ask the other side, and usually they'll give it to you. But start getting too long, and they start getting a little bit antsy, whatever. Third big discovery tool is called a request for admission. In every lawsuit, there are some things, some detailed facts that really, even though the sides hate each other, they do agree on some of these facts. For instance, in a landlord-tenant case, everybody agrees there was a lease and that it was signed. But that's not really what's in dispute. But it is something that has to be proven. Now, why do we want to spend time going through a lease and saying in front of a jury who's sitting there tapping their shoes, they want to get back to their families? Why do we want to spend the time saying, I'm handing you what's been marked as Exhibit A, can you identify this for the record, please? That's the lease I signed. And when did you sign that? Oh, I signed that on the 15th of January, 2018. And is that your signature? We can just do this to a request for admission. Please see attached Exhibit A and admit or deny whether that is a lease that you signed. If they say admit, they're not disagreeing. They may be suing under that lease too for you. Yeah, they agree this is a lease. So there are certain things everybody agrees on. That's what's good for requests for admissions. Fourth thing is what's called depositions. So after you send out your request, and it doesn't have to be after, the order can be any way you want, but usually it's after. After you send out your request for discovery for request for production of documents, after you've got your responses back to the interrogatories, after you send out requests for admissions, you've got a fairly good idea what their case is all about from a paperwork standpoint. Now you can ask for a deposition. and you can require the other side to go someplace where there's a court reporter in a conference room, and you sit down, and that other person's attorney is going to be there, and that court reporter is going to swear that opposing party in, and then your attorney gets to ask that person questions under oath. State your name for the record. Where did you go to school? How far did you get in school? Blah, blah, blah. Some introductory questions. You ever been in a lawsuit before? And then they start actually getting into the actual case itself. And what you're doing basically, there's 3 reasons you want to do a deposition. Number 1 is this is under oath. So once that party gives an answer to the question, they're kind of trapped. That's their answer. They can't go back on it later when that answer becomes inconvenient because they swore to it under oath. And you can cross-examine them with that deposition video or transcript if it comes to court and they reverse what they said at the deposition. Now wait a minute, back in July, you remember we took this deposition? Yes. And didn't you say that you didn't know this person? See, that's how you would do that. So you trap them into one story. Second purpose for a deposition is just to figure out what's going on. Sometimes it's like there's 2 sides to every story, and you've heard your client's side, and you've heard a very, very stilted version of what the other guy's going to say. So now you get to hear the other side really tell it like they mean it, like they're telling it from their point of view. And that's very, very valuable for an attorney to know both sides, because there's always going to be weaknesses to your side and strengths to your side, and there's going to be weaknesses for them and strengths for them, and doing a deposition will show you those strengths and weaknesses. A third thing that you get out of a deposition is you get to size up the other side. You get to see, is this person going to play well in front of a jury? Does he or she look like a sniveling rat trying to sell out his own family members and just looks disgusting, and then the jury's going to want to throw rocks at him? Or does this guy come off as the real deal? I mean, does he come off as, gee, the jury's they're gonna like this guy. They're gonna think he's telling the truth. That's a weakness for your case if it looks like the other side is going to do really well in front of the jury. And a deposition is a chance for your lawyer to size up the other side and get an idea of how they're going to look to a judge or a jury, who's ever making the decision. Okay, so that's a fourth technique for discovery. There's a fifth. You can do subpoenas, where people aren't actually a part of the case. Maybe you need some records, so you send a subpoena out to the sheriff's department and say, I want all the police reports that say this. Or you can subpoena this doctor who also saw you but won't give you the time of day as far as the records. You can subpoena the records, and under Civil Rule 45, they've got to bring them into you. So that's discovery. It's basically, like I say, it's telling all the card players what all the other card players have in their hands. Now we get to the third stage. Now that we've got all this information, the third stage, and that discovery process can take anywhere from usually 6 months maybe to, if it's a big, long, involved case, it could be a year and a half of discovery. So that can be a real time sucker right there. Now, the third stage, we're going to get to dispositive motions. We talked about this a little bit earlier. It's going to be a little bit like that motion to dismiss, only now we can go beyond what's in the complaint. Now the court no longer has to believe the allegations of the complaint is absolutely true in order to make a decision to dismiss it. Summary judgment, in an overall sense, is a way that a judge can use to narrow down the issues in the case. Because when the case first comes to the court, you're going to put all the stuff you have that you could possibly use against your opponent, you're going to put it up there. You're going to throw all the mud up against the wall. And some of it's going to be really good mud and it's going to stick, and some of it's going to be really, really shaky and it's going to fall off. And so this process of summary judgment is how we tell the difference between the good mud and the bad mud. So what you can do is you can say, gee, you've got a case against this person for, say, unjust enrichment. And you say, well, but they signed a contract. And so you can say, One of the rules in law is that you can't recover both on unjust enrichment and on the contract. You don't get unjust enrichment when there's a valid contract. So, Your Honor, they admit in their discovery, they admitted in deposition that there was a contract, they signed the contract, and that it was a valid contract. Because of that, Your Honor, because of that admission, this unjust enrichment claim, you got to dismiss it. And then the other side comes in and says, well, and then maybe they say, that's not really the law, Your Honor. We're pleading this in the alternative. The rules say we can do this. And so the judge says, wait, well, let me slow this down, parties. Plaintiff, you're saying that the facts are A, B, C, and D, and defendant, you agree that the facts are A, B, C, and D. You're not disputing the facts. What you're really disputing is what's the law. Does the law allow you to prevail or not prevail on this claim or on this defense, maybe, because you can do summary judgment on those too. And everybody says, yeah, we're not disagreeing on the facts. A, B, C, and D, that's all there. But we're just asking you for a ruling on the law. So the judge says, well, okay. If we're not going to argue over the facts, then I can take this into my chambers with my staff attorney, my research guy, and we can look at it, and we'll make a decision based upon the law. And then that's something that's ripe for summary judgment. Now let's look at this differently, and the court says, okay, so we all agree that A, B, C, and D are the facts? And the defendant says, no, we A and B, yeah, but not C and D. No, we disagree with that. At that point, the court says, stop. I'm not going to listen to any more of this on this issue. If you guys don't agree on the facts, if the facts aren't clear, then now is not the time for me to believe somebody or not believe somebody. We're not at that point yet. That's for the trial. If you guys can't agree on the facts, then you're not getting summary judgment. This case continues on, and that claim or defense continues on. Okay? So at that point, summary judgment will be rejected. Or they may say, yeah, well, we agree on the facts, but plaintiff says this is the law, defendant says that's the law. I looked it up, defendant's right. They don't have to have those facts in there, or whatever it is. But that's how you narrow these things down. You can go from a 17 or 20 claims in a case, break it all the way down to 2 or 3 claims in the end. That way the jury doesn't have to sit there and sift through all these other things that just were legally untenable, okay? It's a narrowing of the funnel. It puts things into a framework so that when we actually go to court, we can use the court's time as quickly and as efficiently as possible. That's dispositive motions. Last, the 4th stage, you guessed it, trial. That's where the attorneys get up and they give their opening statements, they examine their witnesses and cross-examine their witnesses, and then the other side gets to put on its witnesses, and so on and so forth, and then each side gives its closing statements, and then the court decides. So that's I don't want to say that's a pretty straightforward thing because it is a very complex topic, but it's not really what we need to be getting into right now. Giving you the stages here, that dispositive motions stage, that's usually going to, after discovery ends, there'll be a deadline in there, usually about a month after, maybe 2 months after, for dispositive motions to be filed. And then when they're filed, then you get a chance to respond to them. And then the judge will take however long the judge takes to respond. So it could be a 2 or 3 month period. It could be a 6 month period. So that could be, you have to sort of let that factor into your decisions on how long this court battle may take. And then lastly, your trial. I mean, there are trials that go for a long time, massive, tort actions, class actions, extremely long murder trials. I mean, the OJ trial went forever back in the 90s. But generally, most trials are going to be over in a week or 2 at the most. So that's your final stage right there. Now, yes, there's appeals, but that's a whole nother subject area. But those are your big 4 stages to a trial. You got your pleading stage, you got your discovery phase, you got your dispositive motion stage, and then you got your trial.